great.
Yes, ma'am. Thank you. Dave Howard. Hi, Catherine. Nice to see you. Hi. Nice to meet you. Hi, Nancy. Dave Howard.
Dave, good morning. Matt Klein.
Matt Klein. Nice to meet you, sir.
Ivy Clemens.
Nice to meet you, sir.
All right, make yourself comfortable, David. We're going to have you start out, as we have almost everybody start out, and tell us why you want to be a circuit court judge.
Before I answer that, I just want to thank you all for being here. I know how much work you've put into this, and it's a very important job, and I want to thank you on behalf of all the applicants. I know how long it took me to write this thing, and I can imagine how long it took to vet us and to read everybody's. The reason I want to be a circuit court judge is that I want to do something important with my life, and I know that my personal and professional experience has prepared me to be a great circuit court judge. We've been blessed in the 7th Judicial Circuit with having a very stable, knowledgeable, and very well respected judiciary for many years. Recently, we've had a lot of turnover, and quite frankly, we've lost Judge Walsh, we've lost Judge Beck, we've lost Judge McFerrin-Smith, people I grew up in the legal profession respecting and knowing how much knowledge they had and just a lot of respect. During this time where so much turnover has happened, I've been approached by a number of judges and a number of attorneys who expressed concern about the future strength of the judiciary, and they asked me and told me that they thought I would be good. They thought I had the right judicial temperament and that I had the right knowledge base, and they quite frankly encouraged me to apply for this position. They also told me that if you're hesitant about the right time, that maybe you want to wait longer, this is the time, because as I said, we had a very stable judiciary for many years, and because of that, now that we're losing so many at the same time, I expect we're going to have a young judiciary that's going to be stable for a long time. So I took what they said, and this was a goal of mine before, but I took what they said. I talked to my wife. I very much considered everything. Is this the right time for me? Is this what I want to do? And it absolutely is. Some of my hesitation with trying for this position was I quite frankly love the job I'm doing now. Before law school, I either wanted to be a teacher or I wanted to be a lawyer. I obviously chose to be a lawyer, but if you read my application, you know that I was a martial arts instructor, I was a fencing instructor. So I had a background in teaching, and I love teaching. I love affecting people in that way and helping them achieve something that they want to achieve. In 2012, when there was an opening vacated by Honorable Steve Henderson for the position of being managing attorney for juvenile and misdemeanor in Daytona, I jumped on it. It was a dream job. That's what I said in my interview, and it was. I finally had the opportunity to be both a teacher and a lawyer. And that's essentially what I've been doing since 2012. I feel that this is an important job. It's a rewarding job. I essentially handle 10 to 13 attorneys and an equivalent of staff. I run half the Daytona office. And it's a very important job to me because the way I train these future attorneys, these are brand new attorneys. I touch and mentor at least 8 new attorneys a year. And since 2004, that's probably, I don't know the exact number, of 24 to 30 some attorneys have come through the state attorney's office under my mentoring. And it's an important job, and I feel satisfied and rewarded because this is not just the future of the state attorney's office I'm entrusted with, but the future of a large portion of our judiciary. The reason I'm willing to give this position up, if I was deemed worthy by yourselves and the governor for this position, I think being a circuit court judge is even more important than what I'm doing. I'd be able to help a lot of people. I would be able to affect a lot of people in a positive way. And like I said, I want to do something rewarding with my life, and I think being a circuit court judge would be something that was rewarding, and I would be able to continue the service to the community that I've done as a prosecutor for roughly 10 years between my first time and my second time as a prosecutor. But that's why I want to be a circuit court judge. But more importantly, I think in connection with it is why should you feel comfortable that I'm qualified to be a circuit court judge. And I submit to you that I am qualified. I entered the state attorney's office in 1998. I stayed there until 2003. I tried a lot of jury trials, both in felony and misdemeanor, and I learned, quite frankly, how to be an attorney at that time. And I know my experiences, there gave me the confidence to really do anything in law. When you become a prosecutor the first day, they hand you a box of files and say, go. There's not a lot of training. When I went there wasn't a training supervisor like me. It was just go. You have a trial within the first month, and you just have to figure it out. And that kind of experience gives me the confidence that even if I was put in an area where it's not my strongest suit, I would be able to adapt because, it's just like anything else. You read the law, you consult with your coworkers. In this case, if I was a judge and there was something I didn't feel comfortable with, obviously I'd go to the statute book, I'd go to the rule book, I would talk to the other judges after I put in the work. I don't want to belabor them, initially without, doing the work myself. Ultimately, it's about being prepared. And I know that I've learned how to do that from being a prosecutor the first time. The other thing about being a prosecutor that's a little different than being any other type of attorney is your duty's a little different. As a private attorney, your duty is to do everything you can to zealously advocate for your client within the ethical rules. As a prosecutor, that's not my job, and it's not what I teach the prosecutors that I'm supervising. The job is to do justice. The job is to do the right thing. And if you look at my application, you look at my significant cases, I didn't put in the cases where I sent people to life in prison. That's not, I've done that, but I didn't put that in there. Those weren't the cases that I thought were significant. I tried to put in my cases where I showed I did the right thing when I didn't have to. That, there was one where I won a case, and then I found out later that the officer, my main officer, was someone that was untruthful, and I allowed the case to be overturned and to plead to a lesser offense. So that's what I've tried to do through my career, and that's why I didn't put necessarily the harshest cases in there. I wanted to show, a judicial temperament that I'm trying to do the right thing, because that's really the job, and that's what I teach.
Mr. Cromartie, I don't mean to be unkind, but we just had, you talked about timing. One of the first things you said was timing. We just had 2 vacancies, and we sent up 11 names, and 9 of those folks are back before us.
Yes,
and now
ma'am.
we have 1 opening and 6 spots. Why should we put you in one of those spots instead of the 9 names that we sent up last time?
Well, like I said, I think I'm qualified. I think I have the right temperament, and I think I'll do a great job. I'm not going to disparage the other applicants that's went. There's very good applicants. I very much respect Steve Henderson. I respect Judge Stens, but I offer some things that they don't. Steve's never been in private practice. I was in private practice for 6 to 7 years. I have some experiences he doesn't have. He has some experiences I don't have. I think we're all good candidates, but I think I would do a fabulous job and equal to any of them.
Mr. Cromartie, why did you leave private practice to go back to the state attorney's office?
Roughly around 1998, everything crashed. Our business cut in half overnight. It was amazing. As soon as the new election happened in November of '98, my practice half. There was enough business. We probably had, I wouldn't say half, but the business cut down quite considerably. I think because of the crash in the economy, all of a sudden people didn't have credit. We were chasing the dollars. It was something that I really enjoyed being a prosecutor, and I was willing to go in at the bottom. And like I said, a year and a half later, I was running half the Daytona office. So, hard work counts, and that's what I went and did. And my wife is now doing great, but at the time, like a lot of people, the economy really, really hurt, and that's why.
Mr. Cromartie,
Yes, sir.
the case you just mentioned a few minutes ago, you wrote extensively about it in your application, one of your significant cases, where you tried the case, the gentleman was found guilty, and then you later agreed for that case to go back and keep bargaining it down. You had some serious doubts about being able to get in admissible evidence in order to convict him in the first place.
Yes, sir.
Do you think it was good judgment to go ahead and prosecute that case with the struggles you went through?
Yes, I knew he was guilty. I mean, I knew what the blood results were there. I don't know how many of you read that case, or I'm not sure, but in that particular case, what had happened was the Holly Hill Police Department doesn't have an intoxilizer machine. They have to rely on other agencies when they're open. And the individual in question was stopped. He was read what's called an implied consent, and he agreed to take a breath test. And unfortunately for me and the Holly Hill Police Department, they couldn't provide one. They called Daytona, they called Ormond, and no one had one available. So what he did was he reread implied consent and said, you have to give me a blood test or you're going to lose your license. Well, the law doesn't allow that. So the guy agreed, but it wasn't consensual because he read something in the law that wasn't true as a consequence. So the blood results came back. I don't remember the exact results. I think a 232, something like that. So I knew he was guilty. However, I knew that under the law, I wasn't going to be able to get that. I had good officer testimony from the original officer, Officer Buckner, and there was a conflict. I had the second officer who came a little bit later said, you know, the first officer said the person was just drunk as a skunk, couldn't stand up. The next one said, oh, he's impaired, but he's not, you know, so drunk, you know. And then the last person, the one who took the blood, said the person was stone cold sober. So yes, I had difficulty, but I had the absolute knowledge that that person had been impaired, that he was well over the legal limit, and I was right. So yeah, I went forward. It was a tough case. I offered a good plea bargain. They didn't take it, so I took it to trial knowing I'd probably lose, but I ethically could go forward. I knew it was the right thing to do.
When you become a circuit judge, what do you think will be the challenges with being fair to all litigants with your prosecutor experience? In other words, you've been a prosecutor a long time. Will you have that slant when you get on the bench?
No, sir, I don't feel that I will.
How will you overcome that?
I was in private practice 7 years. I represented a lot of criminal defendants. I've represented people in a lot of matters. I've done partition actions. I've done accident cases, both for the plaintiff and for the defense. I've done a ton of family law. I'm not just a prosecutor. I know that's what a lot of people know me as because of my present position, but I was in private practice for a long time, and we were successful for a long time. So no, if you read my Victor Evans case, I hope that you did, because that's eye-opening. I had the, well, pleasure, but it was heart-wrenching, it was gut-wrenching that I represented someone I knew to be absolutely innocent, and he was charged with a burglary with a battery, which is something that's punishable by life. The evidence was circumstantial, and the prosecution absolutely believed he had, you know, not only broke into this house and attacked this woman, but that it was an attempted rape. You know, I knew from the beginning. I talked to this person. I knew from talking to him in a way that the prosecutor wouldn't, that this person hadn't done this. And the burden of facing that, to know that it's easy to represent someone that you know is guilty, and you get the best deal that you can and you work the case, but when you know that person's innocent and they're in your hands, that is a burden like no other. And luckily for us, you know, we were able to show that the person absolutely lied. They confessed to making it up, and we were able to get the case dropped. I encourage you to read it. It affected me quite a lot. And I always bring that example to my prosecutors when they're trying to do a circumstantial case based on one witness testimony, because that's what that was, and it shows the danger of possibly false identification. It shows the danger of people that have a motive. This lady moved her house when the event didn't even happen. She said she was being threatened by people. I think she was trying to get the attention of her husband. I'm not sure. But they actually moved from one house to another because she claimed that she was being harassed. And, you know, it was a real eye-opener, to be honest.
David, thank you for coming in. Our process is that we will interview everyone today, deliberate, and we will let everyone know by the end of the day via a phone call.
Thank you very much for your time.
Thanks for coming in. Take care.